Good morning. A lot is going on in Donald Trump's world in court. And I thought, who better to have on the show than Danya Perry, my colleague who I work with now. And she represents Michael Cohen in several matters, but she just spent a couple of days in Judge Arthur Engoron's courtroom in New York State in the civil fraud case involving Attorney General Letitia James, who's bringing the sweeping allegations against Donald Trump, his kids, and others. So we thought we'd start the day with having Danya here. She's been here before to talk to us. Danya, tell us what you can tell us about everything going on, what it was like to be in the courtroom, etc.
Well, the case has been going on for weeks, as you know. I was there only this week, Tuesday and Wednesday, for the testimony of my client, Michael Cohen. He was on direct a good chunk of the day on Wednesday. And then the balance of the time he was on the stand, he was on cross. And there were various breaks during the day for such things as a contempt hearing in which Justice Engoron found Mr. Trump in contempt for having violated gag order.
Were you there for that?
So we weren't allowed to be. There was also at the same time, Mr. Trump had been doing a little witness intimidation on the side against my client. And so I had flagged that for the government lawyers.
What did it look like when you say, what do you mean he was doing witness intimidation? What was he doing?
I mean, he's doing what he typically does. So look, the first time I met Mr. Cohen was when he was in solitary confinement, having been remanded there for, having the audacity to write a book about Mr. Trump. So the administration didn't want him to do that. So they essentially threw him into prison. That's a whole side story. But that was the first act of retaliation that I encountered with Mr. Cohen. I represented him again when Mr. Cohen had the audacity to testify as a witness in the grand jury, and then in March will be in trial court in the Manhattan District Attorney's criminal case against Mr. Trump. And a week after Mr. Trump was indicted in that case, Mr. Trump filed a $500 million retaliatory lawsuit against Michael in that case, which has since been dismissed. And so,
why was it dismissed? Don't tell.
See, all these things have their own,
but tell us why it was dismissed. I think it's important to hear.
So we were pressing for discovery. So Mr. Trump was the plaintiff in that case, but was, at all costs trying to avoid our taking his deposition, and he was trying to avoid document production. And so we were in front of the judge a lot with discovery disputes. Finally, the judge thrice ordered him to appear for a deposition. And the last time the judge said, if you don't show up for this deposition, there will be sanctions. And so I prepared, 3 times, but we were ready to go. I think it was 1 or 2 days beforehand. Rather than show up and be deposed, I like to think, by me, I think that has to have been the real kicker. But no, I think he didn't want to be deposed. And so about 2 days before his scheduled deposition, he, quote unquote, voluntarily withdrew the entire lawsuit. So he self-dismissed that suit. Remains to be seen whether or not Mr. Cohen has his own remedies there and wishes to pursue some kind of countersuit so that we eventually get to take that deposition after all. But that's, there are some things between here and there, including that district attorney's criminal case that is to be tried in March, and for which Michael is going to serve as a trial witness. And so, getting back to the theme of witness intimidation, the night before Michael was to testify, he was served with a document subpoena by Mr. Trump's lawyers in that district attorney's office case, which, the timing of which and the nature of the documents which were sought certainly have the whiff of intimidation. And then during his testimony, Mr. Trump was giving press conferences about my client and, posting about him. And so, it's very much a pattern of conduct here. But on Wednesday, yesterday, what the judge was really concerned about, what the topic of the day was really the intimidation by Mr. Trump against the judge's own law clerk. As extraordinary as that sounds to even say, Mr. Trump had been coming after the judge's principal law clerk, who sits next to him, who consults with the judge, as happens in every courtroom, in every courthouse in America. For whatever reason, Trump's team and he really took offense with her. They called her a second judge. They called her a partisan hack. They called her a lot of names, and he posted about her liberally, probably the only time you use that word for him, but prodigiously, and also spoke about her again after the judge had once fined him or sanctioned him for having violated a gag order about, speaking about the judge's clerks. And so he did it again yesterday. The judge put him on the stand, tested his credibility, found him not credible, and swiftly fined him $10,000. So we were not in that courtroom because, as the witness, you're not there for proceedings that don't involve, the witness or his attorney. So we missed some, but not all of the fireworks yesterday. There were some others, including when Mr. Trump stormed out of court when he didn't like one of the judge's rulings.
So were you there when that happened?
Yeah. He stormed.
And so he would tell us about it. He literally just he stood up and walked out.
So Michael was testifying on cross. I'll say, I, as his attorney, I have many functions, but I'm not allowed to object. That's, the party lawyers are supposed to do that. So I'm just squirming in my seat because every single question on cross-examination was improper in some way or other. Lacked authentication, lacked foundation, called for hearsay, assumed facts not in evidence, did not, again, mostly they just didn't establish foundations, or they misstated the prior testimony, or they were so compound and misleading as to be virtually unanswerable. But the witness was required to answer with a yes or no, which was literally impossible in one of these meandering, winding questions. And so that's what was happening in cross-examination. And Michael was getting, a little agitated when required to answer with a yes or no to a question that was simply not answerable in that way. And the defense was acting as though this was the whole thing. The whole thing was a show. There was a lot of acting. It was a performance. Because again, the rules of evidence, the rules of civil procedure did not seem to apply. And so they would ask a terrible question, and they would get a very ambiguous answer that probably wasn't responsive because the question, again, was not answerable. And they would act as though they had won the case. They would throw up their hands and say, aha, literally. I mean, I'm not exaggerating. Like, I don't think they said gotcha, but they might as well have. So at one point, Mr. Trump answered a very complicated, impossible to follow question in such a way that they thought they had got him. So
Mr. Cohen,
who was on the stand. Yeah. Mr. Trump threw up his hands, all of the lawyers threw up his hands and say, we got it. And so the second he answered the question in that way, one of the lawyers got up, Cliff Roberts, and said, Your Honor, we demand a directed verdict. We've won this case. The whole thing falls apart. This is a sham. I'm paraphrasing a bit, but not much. He requested a directed verdict in the middle of the case, which isn't something you do. It's like, I was on MSNBC last night with Lisa Rubin, and we were joking. It was like an Elle Woods moment where the whole courtroom erupts and the judge dismisses the case. I mean, it just doesn't, it's not real life. It's play acting. And the judge very swiftly and handily denied that non-motion. And Mr. Trump pounded the table, literally. I know it's like a trope, that you say about lawyers, like pound the table.
Objection.
Yeah, you're out of order.
Exactly.
He and he just stormed out, and his team and all the Secret Service and was required to kind of scramble and chase after him. But he was red in the face, he was furious. He said something or other that I couldn't quite capture, like, this is ridiculous, or this is a lie, or something, and went out and gave a little impromptu press conference about how he just won the case, and left. So
Do you remember what the question was that prompted all of this?
I will try and tell you, but again, it was an impossible question. So Mr. Cohen had testified on direct, as he has since his congressional testimony in 2019, where he first said this was the way the Trump Organization worked, was that Mr. Trump would kind of arbitrarily come up with a number that he wanted the world to think was his worth, was his net worth. And so he would pluck that number out of thin air or his own head. And he was like, okay, this year I want it to be $8 billion or $9 billion. And
Same.
and Michael, don't we all? But he was able to have his minions kind of come up with that number, and they would pick various asset classes and back into them and say, okay, so Trump Park Avenue, we're going to say I'm making numbers up now because that's how this whole
Why not? He did.
Exactly.
That's how it works there. You just
I'll
make it up.
$1 billion, for Mar-a-Lago, or 1.5 for Seven Springs Golf Course. And so that's what Mr. Cohen and Mr. Weisselberg and others were kind of tasked with doing. They understood that that's what the boss was asking for. He wants $9 billion. That's not what he was worth. So how do you come up with that? You inflate numbers. A lot of this was just kind of understood. Like, it's not like, Mr. Trump would say, okay, go to Seven Springs, and instead of valuing it at 500 million, value it at 800 million. He didn't have to, it was understood by his minions that that's what he was saying to do when he said, oh, I'm worth 8 billion, when really the books reflected that he was worth 2, or, whatever. Again, the numbers don't really matter because they're all, picked out of thin air. And so he testified about that on direct, as he has, said consistently. In his cross, Alina Habba, who did most of the cross-examination, pointed to a single line in a very long congressional deposition that Mr. Cohen gave in 2019, where he said, there's a direct question that said, like, were you told, or were you specifically told to inflate the numbers for the statements of financial condition, which are just, the synopsis, really, the summary of Mr. Trump's fake net worth? And he answered no, essentially. There was some hinting of it, no. And that was on cross. And that was their big gotcha moment. Aha, so he didn't ask you to do that. And oh, so you lied. It was either he didn't ask you to do that, or you lied to the Senate or to the congressional committee. But they would, it was always a yes or no question. There's always also a lot of confusion about what they're talking about, whether they're talking about congressional testimony or other statements he made, or his courtroom testimony on direct or on cross. They just wouldn't point to it. And again, they cherry picked this one line out of a lengthy record, because he had given a deposition on one day in February of 2019. And the next day he testified at length in a public hearing. And so that's what they did. And then there was a redirect where Mr. Cohen, oh wait, I may be getting the sequence out of order, but at some point, he did testify, and now it was Cliff Roberts who was on cross-examination. He got him to sound like he was saying that he had not, in fact, inflated the numbers, which is contrary to the whole body of everything he said. But there was one line in that congressional testimony when taken completely out of context, without other words on the exact same page, almost looked like that's what he was saying. And so that's when they had this big aha moment, requested this fake, directed verdict. The judge I mean, essentially laughed at them. He said, he's very emphatically said no. He said, absolutely not. And that's when Mr. Trump, stormed off in a red-faced huff. And then on redirect, of course, the
I
assistant,
think it was orange,
it was
an orange faced.
fired today. On redirect, the assistant AG, pointed him to the rest of the page, and he explained exactly what he meant, which was, Mr. Trump never turned to him and say, look at Seven Springs and inflate it from 500 million to 800 million. It's not the way it worked. There was, and he, as he often has in the past, compared it to kind of a mafia family where you don't say, go kill so-and-so. It's like, it'd be great if that guy weren't around anymore. Within the family, they'll understand exactly what that means. And that's consistent with everything Michael has ever said. So there was no aha moment. There was no gotcha moment. There certainly was no basis for a directed verdict, as Justice Cohen very, easily found. But it was enough, to send the defendant into a blind rage and out of the courtroom.
And Michael's done. He's not testifying there anymore.
He's done. He's off the stand. As I said, mid testimony, he received a subpoena in the next case, the criminal matter,
from the defense lawyers.
From the defense lawyers. So we're moving on to that without much
What
time.
What are they seeking? Can you say?
Yeah, I haven't yet, because it came, mid trial, and we were really, kind of on the seat of our pants. That I've looked at it. Of course, it's outrageous. It's highly quashable, and I'm sure there are other remedies we could seek. I just haven't even really, spent the time yet. That's what I'll do over the course of the next day or so. Yeah,
I mean, sure just the timing. It's so clear, is to intimidate, that he would serve him with that on the eve of testifying in court, right? And Trump didn't have to be there. He chose to be there to intimidate. I think it's to intimidate him.
I see no other. Yes, I would agree. And certainly there was a lot of, glowering in Michael's general direction. And, they caught eyes a few times, and there was a lot of, wild gesticulations, and, and in fact, that dramatic turn when he stormed out of the courtroom. Look, the timing is always, they don't even pretend, like I said, Trump filed his $500 million lawsuit within a week or so of the Danny indictment. And here, Trump was indicted back in April, I believe, in that case. And so why he waits till the eve of trial with this lengthy, burdensome, totally inappropriate subpoena that was served directly on Michael, which is also highly unusual. I mean, he also has counsel, and the Trump team knows that. I was sitting right there in courtroom. So, there's a lot that was improper about it. And so I just have to, consider the options, but it will certainly involve, at least a motion to quash.
I have one question, and I so appreciate you taking the time to tell us all of this. But did Trump ever try to assert attorney-client privilege and say Michael can't testify?
No, he didn't.
Why? I mean, I'm not saying it wouldn't.
Yeah,
but
no, it's a good question, especially because that was one of the premises of the $500 million lawsuit he had filed, is that Michael is, invading attorney-client privilege. But then, his own attorneys are asking those very questions of Michael on the witness stand. So, I think and it really hasn't been litigated, but there are, some well-known exceptions to attorney-client privilege that, that,
of course, but like crime fraud exception.
Fraud clearly applies.
But why? But you'd still raise it and make the judge rule on it. Like,
right. Well, there was a ruling. Well, let me say, before we got involved, there was a ruling, I believe, with respect to another attorney, that work on the valuation aspect of the business, which is what all of this was was not a legal function. It was a business function, if that, really, it was just like, magic and plucking, rabbits out of hats. And Michael did testify on direct that he was functioning not as a lawyer, but as a member of the Trump, business team, I suppose. So I think that's how that was dealt with. And truly, I actually don't believe there were any real confidences. There were any confidences that were,
of course, but they make so many other frivolous motions.
Yeah.
I just am surprised they missed that one, at least trying, right?
Maybe they're hoping for a second bite of the apple, in that lawsuit that they brought against Michael. I have no idea, but I would argue that they've waived it at this point by asking.
Of course, yeah, I agree.
So
I think so too.
It's hard when you try and get in their heads to kind of perceive any form of legal strategy going on. You're in crazy town. You just it's impossible. And I don't mean to be as disrespectful as that sounds. I sat there for 2 days, and I mean, there was a lot that went on that was high drama and that was even shocking, some of the moments we just talked about, but mostly as like, just a practitioner, I was just floored by the lack of, first of all, courtroom civility, decorum, but also just the way that the rules that apply to all lawyers did not seem to apply. Every once in a while, really sporadically, someone would, come to their senses, rise to their feet and say, wait a minute, that's hearsay. Well, really, you just let in 10 other exhibits exactly like that. That's from the exact same problem. So yeah, I don't try and get in their heads and understand why they do what they did or didn't do what they haven't done.
Wow. That's crazy. It's funny. I had never understood the strategy of a defense attorney who's like cross-examination saying that was a yes or no question, only answer yes or no. Because as a prosecutor, what I would do on redirect is I'd stand, if the witness is trying to get something out, I mean, I would just stand. Yeah, exactly. I'd stand up and say, when you were asked, that question and they wouldn't let you finish answering, it seemed like there was something you wanted to say. What was it? It all comes out anyway. So, it's an art.
That's exactly what happened here on that, the congressional testimony. So as much as they, like to, turn around and pose, posture, it was all just for show, because that was completely rehabilitated, if you want to even call it that, on redirect in the first question or two. So I agree. There was a lot of that. And there was a lot of, I mean, a lawyer would be kicked out of certainly federal court, most courtrooms, for the kind of the incivility. And every single time Michael would answer a question, Alina Habba would say, oh, I thought so. Or, oh, isn't that telling? And there was always some commentary from her, some speech about the testimony. I mean, that just doesn't happen for good.
You're not allowed to editorialize.
It wasn't a jury to do that for. And I think Justice Engoron just kind of was over, I don't think it was affecting him. And so he didn't, every once in a while, he'd say like, okay, all right, let's not do that. But it was it was every question. And, I think she thought she was making some headway and putting Michael like on his heels. He was very calm. I think, he got what she was doing and just wasn't falling for it. So, it was just like a waste of a lot of air.
Wow. Well, it had to have been really intense.
It was pretty intense. It was kind of fun. It was like the court was full, with different characters, and all these different, there was a nice coterie from the DA's office. The attorney general herself was sitting in the front row and, at one point, as a kind of a joke, like objected because there was something directed at her. So all of, Trump's criminal attorneys were there, some of whom I know. And, so it was an interesting gathering, right? There were, and it was also interesting. This is the first time Mr. Trump has taken the stand, and certainly the first time that there has been a credibility finding about him, this one, an adverse one.
That's a
So
great point because he's been deposed,
in deposed,
but this is the
I don't know the
first
history.
time. Yeah.
Um, and so, they're sitting there during Michael Cohen's testimony saying, he's perjuring himself. He's a liar. No credibility findings against him, but there was against, their client. And so it was quite a turn of events.
I mean, I think we need to really punctuate how unusual it is in the middle of a trial, in the middle of testimony, for a judge to demand that the defendant take the stand, right? And have to be sworn under oath, and then to find him not credible.
I mean, it was
right?
bananas. Like you and I have been practicing for a long time. Have you ever seen that?
Never.
Never seen it. And that's in part because, we rarely see gag orders, right? Because defendants usually act in their own self-interest, their own best interest, and don't do stupid stuff like that.
This is barely a gag order. This is don't threaten my court
my
staff.
law clerk. So
Yeah.
have you ever seen that happen? Someone actually
Exactly.
threaten a member of, the staff? Like, it doesn't happen, let alone more than once. So he'd been warned. And when he made the statement, the offending statement that got him, the second sanction, he had this little impromptu press conference, right, outside the courtroom. And his lawyers were standing right by his side. And it's crazy. I think, we've heard a lot of testimony in the past couple of days about Michael Cohen's role as Trump's personal lawyer, and how he just became such a true believer, so invested with the work and the ethos, if you want to call it that, of the Trump organization, of Mr. Trump himself. He would do whatever it took. He really was a lackey, a stoolie, and there was a mob culture. And they would do anything. And it was kind of surreal. And Lisa Rubin and I, talked about this, and she's made the point, but I felt it very acutely. Kind of surreal to see Alina Habba. She's the new Michael Cohen. She sat there next to Mr. Trump when he's making a statement that she had to have known violated the judge's gag order, and that they were going right back into the judge's courtroom, and that he would find out instantaneously about it. And she just let him do it. And so I think, when you have lawyers who cannot control their own client, you have a client who's out of control and who would do things that are really against his own.
But then
interest.
they go on record and they lie on his behalf and say, oh no, he was referring to Michael Cohen. There's no, that just strains credulity. And the judge found that there's no way that that's what he was referring to. I mean, when he's talking about Michael Cohen, he has no problem
That's exactly right. He knows very well how to go after him in a very focused, directed way. Yeah. And he did it in that very same statement. He said, Michael Cohen's a lying liar. And then he turned to the judge and his clerk. So
exactly.
I think there was no ambiguity.
Not at all. And his lawyers would lie. It's one thing to not be able to control your client, but then to go into court and lie on his behalf is, that's, you're actually, you have a duty to your client, but you also have a duty to the court first and foremost. You can never lie. And if your client's lying, you're not allowed to put forth that lie. I mean, it's just outrageous.
Look, Michael Cohen went to prison for it. And now you have a long line of attorneys who are.
What is it about Trump? He's like a cult leader. Seriously.
That's how Michael describes it. He alternatively as like a mafia boss, but mostly as a cult leader. That people truly drink the Kool-Aid. That he must have this. Look, there's. It's not just his immediate, group of cronies. It's a good chunk of.
Yeah.
American society. They see something. And it's fascinating. It's just absolutely fascinating. It's hard for those of us who haven't drunk it to see, but it's certainly real. And you've got a long line, hundreds now of January 6th rioters who are going to prison for it. And you see many, many attorneys, who worked for him, who lied for him, who committed crimes for him, who are now facing the same consequences as Michael Cohen. And let's see where Alina Habba finds herself in a couple of years. I mean,
as some people say, MAGA stands for Make Attorneys Get Attorneys. So
That's apt, very apt. That's what the hats stand for. Yeah.
well, any final words that you can think of? Anything else we missed? I missed asking you about.
Um,
How's Michael doing?
he's great. He look, I've known him for a long time, and because I've represented him in so, many different fora, and I've, I've read all of his books, I've read his congressional testimony, I've listened to his podcast. He has been remarkably consistent, and so he was telling the truth, and so that usually makes testimony relatively simple.
Yeah, it's
And
always hard to remember the lies, right?
yeah, exactly. But when you've been saying the same thing over and over, I mean, he testified on direct exactly the same way he did on cross. Now on cross, they acted like they had this fantastic breakthrough, like they got him to admit, about his lies. But those are the exact same things. Yeah, he lied to Congress, and he pled guilty to that, and he said that on direct. So when they're like, so you admit that you perjured yourself, and you, yes, I just did, and I have, for 4 years now. So he was fine. It's I've never been in the hot seat. I hope never to be. I'm sure it's unpleasant in some ways, and he's, there's been a lot of drama and vitriol, directed towards him and his family. We had a lot of security around us because he's had real threats made against him. So, and on the other side, he's gotten no benefit. He's one of the few people who were prosecuted, who served time. He was not immunized or given any other benefit for his testimony yesterday. The attorney general didn't even prepare him for this. So they didn't meet with him. They just put him on the stand. I think they didn't want, any insinuation from the other side that he's been prepared or rehearsed. Or
have you ever not prepared a witness when you
ever,
not one single time?
It was shocking, absolutely shocking to me. So I prepared him, but I don't have a lot of documents he was shown. He hadn't seen it since 2013. It was remarkable, but I'm sure there was a good strategic reason for them, but it was very uncomfortable for him. And they also didn't apparently want to object a lot. So there was stuff or questions that implicated various privileges, marital privilege, I think his own attorney-client privilege, that might have implicated, his Fifth Amendment rights, that were inappropriate questions. And I think they wanted to make a point. And so they largely sat in their seats. And Michael had to, being well prepared, he actually lobbed in most of his own objections. That's inappropriate. That assumes fact, not evidence. That's been asked and answered. I mean, it was remarkable.
Wow.
I did a very good job.
I was wondering why he was doing all of that when I read it, because, witnesses aren't supposed to do that. But I had no idea that the Attorney General's office was not preparing him and not objecting. It sounds like they wanted to just be kind of like, he is who he is. We're not getting in bed with him one way or the other, just like we're calling defendants and other witnesses. We're just putting it all out there, Judge, for you to see. But still, that's kind of,
it was very uncomfortable that I could neither object for him nor count on anyone to object on his behalf. So I admittedly prepped him to self-object, and he did a pretty good job.
Good for him. One other question, though. You mentioned taking the fifth. I mean, he testified under oath the last couple of days about the asset valuation issue, and there's still an open criminal investigation at the Manhattan DA's office on that. Did he take the fifth on any of that, or was he concerned about that, or were you concerned as his lawyer?
I was concerned about that. So he just brought me in. He did not have a criminal defense attorney on his team. He didn't, he really was largely unrepresented. He had a friend who was with him for his deposition, but who's not, this is not his area. And so he already kind of was in the soup, and this, I think, goes to, he is being truthful because he put himself in real harm's way. I mean, so already in the deposition, before I came in, he had said what he'd said, right? And so I got in and I felt my job was just to try and protect him as much as I could. I think he took a chance. I think it's highly unlikely he'll be prosecuted, among other reasons, because of the passing of time. The statute of limitations has expired largely, but certainly taking a chance. And, I think that's, to his credit, that was not brought out for reasons I don't understand. But I think it really punctuates, the real risk, from a security perspective and from a prosecution perspective. I mean, who knows, if there's if Trump wins re-election, will he, I think Michael Cohen, it could really be in harm's way. I truly worry about that. But
I think he'll open up he'll have DOJ prosecute him for these crimes, just to a vindictive prosecution.
I don't even want to let my mind go there. I think Trump has forecast, right, that some of his enemies, are going to be scrutinized. So I'm deeply concerned about that in general. Someone who is actually willing to say that out loud, that's just a horrifying, terrifying thought in a functioning democracy, to go after, one's perceived enemies. But, it has happened to Michael before. So I would be concerned about that. But Michael was willing to testify. He was subpoenaed, right? He didn't, but he could have.
He didn't take the fifth. Yeah.
Could have invoked, and he didn't.
Wow, that's incredible. Well, thank you, Danya. We're so lucky to have you give us this insider view of all things, but in particular, this Attorney General case and Michael Cohen. Thanks so much for joining us. I'm Karen Friedman Agnifilo, Legal AF. Join us every Wednesday and Saturday with my co-hosts, Michael Popak and Ben Meiselas.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.